As a former prosecutor, I'd like to give you some insight on how prosecutors analyze their cases to prepare for court. The first thing a prosecutor would do in analyzing a case is look at the nature of the charges. The prosecutor would want to look at whether or not there's a victim involved, whether or not it's a violent crime, whether or not it's a drug crime, or a theft. Depending on the nature of the crime is going to depend on the way the prosecutor prepares the case for court. If there was a victim in the case, the prosecutor would certainly reach out to the victim and address the damages and what the victim would like to see happen in this case when it goes to court. The state would also prepare for trial in terms of making sure all of their witnesses and evidence are lined up in the event the case does go to trial. The next thing the prosecutor would do is take a look at the defendant's criminal record and find out if they have any prior criminal history, the nature of the prior criminal history, and the age of the prior convictions. In looking at all that information, the prosecutor would formulate a plea offer based on all of those factors. In the event that a plea offer is not reached, the prosecutor would then prepare all their evidence for trial and bring all of their witnesses in the event the case cannot be resolved prior to the trial date. In preparing your case for court from the defendant's side, it's certainly important to show the court and the state that you're taking these allegations very seriously, whether or not you agree that the allegations are true or false. For example, if there's an allegation that there was alcohol involved, you would certainly want to be proactive and get enrolled in an alcohol class to show the state that you are addressing any possible issues that might be of concern. One other thing you might want to look into completing would be an anger management class if there is any type of crime of violence or any type of allegations of assault. And what you're showing the prosecutor and the judge in that event is that you're again taking this very seriously, ensuring that you don't have an anger problem, and if you do, that you're addressing it properly. All of these things are not an admission of guilt. It is a way to be proactive in showing that this is something you're taking seriously, and in the event you're found guilty, these are things that you want to be prepared with to walk into court showing the judge that these are things you've already taken care of and that there is no need to be concerned that you present any danger to the community at large.